Okay, good morning. We're going to get started here. In order to provide our technical and digital staff with notice of the hearing start, I'm going to count down from 5 before calling the hearing to order. 5, 4, 3, 2, 1. The committee will now come to order. Today, the Subcommittee on Communications and Technology is holding a hearing entitled Hold Big Tech Accountable, Targeted Reforms to Tech's Legal Immunity. Due to the COVID-19 public health emergency, members can participate in today's hearing either in person or remotely via online video conferencing. Members who are not vaccinated and participating in person must wear a mask and be socially distanced. Such members may remove their masks when they are under recognition and speaking from a microphone. Staff and press who are not vaccinated and present in the committee room must wear a mask at all times and be socially distant. For members participating remotely, your microphones will be set on mute for the purpose of eliminating inadvertent background noise. Members participating remotely will need to unmute your microphone each time you wish to speak. Please note that once you unmute your microphone, anything that is said in WebEx will be heard over the loudspeakers in the committee room and subject to be heard by live stream and C-SPAN. Since members are participating from different locations at today's hearing, all recognition of members, such as for questions, will be in the order of subcommittee seniority. Documents for the record can be sent to Joe Orlando at the email address we provided to staff. All documents will be entered into the record at the conclusion of the hearing. We're now going to have opening statements. The chair now recognizes himself for 5 minutes for an opening statement. In August 2015, Wesley Greer, a young man who had been recovering from addiction, went to a website seeking to purchase heroin. This website's algorithm took users' information to steer them to groups and individuals who had similar interests. In Wesley's case, the website connected him to a drug dealer. This dealer had been subject to multiple investigations by law enforcement due to his actions on this particular website. After the website's algorithm steered Wesley to this drug dealer's postings, the two got into direct contact, and Wesley bought what he thought was heroin, but in fact was a lethal dose of fentanyl. Wesley was found dead on August 19th. In 2016, another young man, Matthew Herrick, ended an abusive relationship. He soon realized that his ex had created a fake profile of him on a dating app. This app's geo-targeting function and algorithm allowed other users to connect with this fake profile. Through this app, Matthew's ex sent men to Matthew's home and work with the expectation that they would be fulfilling his rape fantasy. These traumatizing encounters, Matthew was followed home and into stairwells where he worked and accosted after a shift, shook Matthew both emotionally and professionally. Matthew repeatedly asked the app to remove the fake profile. The app, however, did nothing. Wesley's family and Matthew share something in common. They were denied the basic opportunity to determine if these websites shared any legal blame, along with the users who posted the content. The question of whether the platform should be held liable, the companies that developed the algorithms, gathered the data, and profited off the users, was precluded by Section 230. They might not have won, but they never even had a chance to get their case tried. These are just two instances of Section 230 locking the courthouse doors to people with real-world injuries caused by online actions. Since I have chaired this subcommittee, we have held multiple hearings on this issue. We've heard from CEOs of the largest tech platforms, we've heard from small platforms, we've heard from experts, and we've heard from those most affected by these behaviors. And these oversight activities didn't start with me, though. Republicans have been investigating this issue as well. They have a number of discussion drafts and bills they have introduced. Many of those ideas are worth exploring. The concept of not providing immunity for platforms' algorithms, for example, are in both the Justice Against Malicious Algorithms Act that I've introduced and Mrs. McNorris-Rogers' discussion draft. There's a bipartisan desire to reform the court's interpretation of Section 230, and the American public wants to see us get things done. I urge all my colleagues, Republican and Democratic, to bring their ideas forward now, and let's work together on bipartisan legislation, because we can't continue to wait. The largest tech companies would like nothing more than for Congress to fight amongst itself while nothing happens. And they welcome those complaining about process, claiming that Congress doesn't understand or saying that this would break the internet, because these platforms don't want to be held accountable. The users suffering harm deserve better from us, and we will act. But for the pandemic, we would have some of these victims with us in the room today. And while they cannot be here in person, the family of Wesley is watching today. Matthew Herrick is watching today. And the advocates for children and marginalized groups and victims' rights are watching today. To start today, we will hear from experts about the harms we are seeing online. And our second expert panel will focus on proposals to reform Section 230. And in a little over a week, Chairwoman Schakowsky will continue this series in her subcommittee, reviewing legislation that can bring additional transparency and accountability for the problems we consider today. I want to thank all our panelists for joining us, and I look forward to their testimony. And with that, I yield the remainder of my time to Congresswoman Eshoo.
Thank you, Mr. Chairman, for yielding to me. By way of background, I was on the conference committee for the 1996 Telecom Act, and I continue to strongly believe in Section 230's core benefit, which is to protect user speech. But algorithms select what content will appear, personalized for each user. The platform is then more than just a conduit, transferring one user's speech to others. Platforms should not be immune from courts examining if algorithmic amplification causes harms. And that's the core idea of the two bills I've co-led. So thank you, Mr. Chairman, for convening this highly important hearing, and I yield back.
Gentlelady yields back. The chair now recognizes my good friend, Mr. Latta, the ranking member for the Subcommittee on Communications and Technology, for 5 minutes for his opening statement.
Well, thank you, my good friend and chairman. I greatly appreciate it. I also want to thank our witness panel for being here today to discuss the potential legislative reforms of Section 230 of the Communications Decency Act. Republicans on the Energy and Commerce Committee are leading on ways to hold big tech companies accountable for the harms caused by their platforms. In January, we announced our Big Tech Accountability Platform, which began our efforts to take a comprehensive look at ways to reform Section 230. I'm proud Republicans have been focused on and remain focused on reconsidering the extent to which big tech deserves to retain their significant liability protections. Every step of the way, we have encouraged our Democratic colleagues to join us in the quest to hold big tech accountable while evaluating how we can reform Section 230. We sought input from the public on their concerns with big tech, from stakeholders on ways to stop censorship while protecting small businesses and innovation, and from members of Congress on proposals that they have supported. Hearing from the public, stakeholders, and members of Congress informed the discussion drafts that every Republican on this committee released in July. Our discussion drafts range from amending Section 230 to holding big tech accountable for taking down constitutionally protected speech and facilitating illegal drug sales to increasing transparency requirements on how social media companies moderate content. Section 230 became law in 1996 in response to several court cases, most notably Stratton Oakmont versus Prodigy Services, to allow online platforms to moderate unlawful or indecent content without fear of liability. It has two main components: a provision that exempts platforms from being liable for content that is posted on their site by a third-party user, and a second provision that exempts platforms from being liable for content that they remove in good faith. The internet has grown substantially since 1996, and it is clear big tech has abused this power granted to them by Congress.
Enter the event panelist numeric password, followed by pound.
They censor conservative voices and use algorithms to suppress content that does not fit their narrative. They hide research that shows the negative impact their platforms have on the mental health of our children. They allow the sale of illegal drugs on their platforms, including fentanyl, which we all know is killing Americans every day. While these actions are happening on big tech platforms, users have no recourse. When conservatives are silenced, the appeals process, if it exists, can be difficult to navigate. Big tech hides behind Section 230 to avoid liability for real-world harms their platforms are causing, including harms to our children. Section 230 is supposed to protect platforms from removing content in good faith, but says nothing about their liability for when they are acting as bad stewards of their platforms. To address this issue, I've offered a carve-out Section 230 protection for platforms that purposely promote, solicit, or purposely promote, solicit, or facilitate material by another information content provider if the platform knew or had reason to know that the kind of intent would violate criminal federal law. When big tech acts as bad stewards on their platforms or as bad Samaritans, they should no longer be entitled to protections under Section 230. We will also discuss legislation noticed on today's hearing, which I am concerned could lead to unintended consequences like curtailing free speech and innovation. Section 230 reform must be taken seriously, and any legislative proposal that eventually gets enacted must be thoroughly vetted. We're at a pivotal time for free speech in America. It is our generation's turn to uphold the rights on which our country was founded. I look forward to hearing feedback from the witnesses on the proposals in front of us today. And before I yield back, Mr. Chairman, I'd ask the unanimous consent that Dr. Burgess, who's not a member of the subcommittee but a distinguished member of the full committee, be able to waive on. Thank you very much. And with that, Mr. Chairman, I yield back the balance of my time.